What is this? Huh? You think you could just breeze through with no inspection? I'll tell you everything out, all of it!
You are making a spectacle of yourself, officer.
A spectacle? How about this? Let's see what's in here. Let's see.
Thank you. That's enough. I'm recording.
Dead man, put that down.
Nope.
Give me the
Hardwell! That's enough. Step back.
The security footage from Terminal C would later become the most watched video in the history of civil rights litigation involving airport security. Time-stamped at 7:23 in the morning on that gray Thursday in early November, it captured every excruciating moment of what unfolded near Gate 22 at Hartfield Regional Airport in the city of Ashford, located in the southeastern United States. The footage shows a black woman in her early 50s walking through the terminal with the measured confidence of someone who has spent decades commanding attention in rooms full of powerful people. She wore a charcoal gray suit jacket over a pearl-colored silk blouse, her hair pulled back in an elegant twist. Her rolling carry-on bag glided smoothly behind her as she checked her phone, likely confirming her gate number or reviewing the speech she would deliver later that day. What the security footage also captures is Officer Dennis Hartwell noticing her from nearly 40 yards away. You can see the moment his attention shifts, the way his body language changes from casual observation to something more predatory. He begins moving toward her with deliberate purpose, his hand drifting to his utility belt in a gesture that would later be analyzed by behavioral experts during the trial. What Officer Hartwell did not know, could not have known in that moment of fateful decision, was that he had just set in motion a chain of events that would utterly destroy his career, expose years of institutional racism within his department, and transform his target into one of the most powerful voices for civil rights reform in American aviation security. He was about to learn a lesson about assumptions, about power, and about the catastrophic consequences of underestimating a stranger based on nothing more than the color of her skin. If you're watching this video right now, I want to know where in the world you are joining from. Drop your city or country in the comments below. This story is about justice, about courage, and about what happens when someone refuses to accept being treated as less than human. If you appreciate stories that go deep into these issues, consider subscribing to this channel because this narrative takes some turns that will stay with you long after it ends. To understand what happened that Thursday morning, you first need to understand who Denise Whitmore was. For 11 years, she had served as a judge in the state criminal court system, presiding over some of the most complex and high-profile cases in her jurisdiction. Before ascending to the bench, she had spent 14 years as a prosecutor, methodically building cases against violent offenders, white-collar criminals, and corrupt officials who believed they were above the law. She had sent murderers to prison for life. She had unraveled elaborate fraud schemes that victimized thousands of elderly people. She had prosecuted police officers who had betrayed their oath, though those cases were always the hardest, both professionally and personally. Judge Whitmore had developed a reputation for fairness that was almost legendary in legal circles. Defense attorneys respected her even when she ruled against their clients because they knew her decisions were rooted in careful analysis of the law rather than prejudice or politics. Prosecutors appreciated her insistence on proper procedure, knowing that convictions obtained in her courtroom would withstand appeal. Her colleagues on the bench often sought her counsel on difficult ethical questions, recognizing in her a clarity of moral vision that seemed to cut through complexity like a beam of light through fog. On this particular Thursday, she was traveling to deliver the keynote address at a regional conference on equity in the criminal justice system. The irony would later be remarked upon by virtually every journalist who covered her story. Here was a woman who had dedicated her professional life to examining fairness and bias in the legal system, about to experience a visceral demonstration of exactly the kind of injustice she spent her days trying to correct. She had been thinking about her speech as she walked through the terminal that morning. She had written and rewritten the opening paragraph a dozen times, trying to find the right balance between acknowledging progress and confronting the persistent inequities that still plagued the system. She had statistics prepared, case studies selected, and a carefully calibrated message about the difference between the law as it was written and the law as it was experienced by different communities. She never got to deliver that version of the speech. Instead, she would deliver something far more powerful, something born from fresh personal trauma rather than academic analysis. But that moment of transformation was still ahead of her. Right now, in this moment captured by security cameras, she was simply a distinguished professional woman making her way to a flight, unaware that the next 45 minutes would alter the trajectory of her life. Officer Dennis Hartwell intercepted her approximately 30 feet from Gate 22. He did not begin with a greeting or an introduction. He did not explain his purpose or present any credential. He simply stepped into her path and issued a command to stop. His tone carried the particular edge of someone accustomed to being obeyed without question. Judge Whitmore stopped. In the thousands of hours she had spent in courtrooms, she had developed an almost preternatural ability to read situations, to sense when something was about to go wrong. That instinct activated immediately. She felt the wrongness of this encounter before she could articulate what specifically was wrong about it. She asked him, in the measured tone she used when addressing potentially hostile witnesses, if there was some kind of problem. He did not answer her question. Instead, he posed his own. He wanted to know her destination. She told him she was catching a flight, indicating the gate visible just behind him. He asked to see her boarding pass. She retrieved her phone, navigated to the airline application, and displayed her digital ticket. He glanced at it for perhaps 2 seconds, nowhere near long enough to actually read the information displayed. Then he demanded her identification. She reached into her handbag, extracted her driver's license, and handed it to him. She watched as he examined it with exaggerated attention, turning it over, holding it up to the light, studying it as if searching for evidence of forgery. While he performed this theatrical inspection, other passengers streamed past them without interruption. A white man in athletic wear and wireless headphones walked within 2 feet of Officer Hartwell and received not even a glance. A white family with 3 children and an overloaded luggage cart navigated around the scene, likewise unremarked upon. Judge Whitmore observed all of this. Observation was central to her professional skill set. She had trained herself over decades to notice patterns, inconsistencies, and behaviors that revealed underlying truths. What she observed in this moment was unmistakable. She was not being subjected to random security screening. She was being targeted, and the only variable that distinguished her from the passengers flowing freely around her was her race. Officer Hartwell asked her where she lived. He asked her where she had traveled from before arriving at the airport. He asked her the purpose of her trip. He asked her what she did for a living. Each question probed further into territory that had no conceivable connection to airport security. She answered each one calmly, though her internal state was shifting from confusion to a cold, focused anger that she kept carefully contained beneath her professional demeanor. When she told him she worked in law, his expression flickered with something that might have been skepticism or might have been contempt. He asked her what kind of law. She said criminal law, which was technically true and also strategically vague. She wanted to see how far he would push this encounter if he believed she was simply an ordinary citizen. He informed her that he needed to search her bag. The way he said it made clear this was not a request, but a command. Judge Whitmore understood her rights in this situation. She understood that she could refuse, could demand a supervisor, could invoke the legal protections that existed on paper. She also understood from her years of experience with the criminal justice system how such refusals often escalated, how they were interpreted as evidence of guilt, how they could transform an unpleasant encounter into a dangerous one. She made a strategic decision. She would comply, document everything, and pursue accountability through channels where her expertise gave her the advantage. She stepped aside with him to a bench along the terminal wall. She unzipped her carry-on bag and stepped back, indicating that he could proceed with his search. What followed was something closer to a deliberate humiliation ritual than any legitimate security procedure. Officer Hartwell removed each item from her bag with exaggerated slowness, examining every piece as if it might contain hidden contraband. He lifted her clothing, her undergarments, and laid them out on the bench in full view of passing travelers. He held up her nightgown, turned it over, set it down. He removed her toiletry case and opened it, unscrewing the caps on her moisturizer and her perfume, squeezing her tube of hand cream, sniffing her lip balm. There is a particular form of violation in having your intimate belongings displayed for strangers to observe. Judge Whitmore stood perfectly still, her hands clasped in front of her, her expression controlled. Inside, she was cataloging every detail, building the case file in her mind, preparing for the reckoning she already knew would come. She noticed the reactions of people passing by. Some averted their eyes quickly, uncomfortable witnesses to someone else's degradation. Others watched openly, their faces showing emotions ranging from sympathy to curiosity to something darker, a kind of satisfaction at seeing someone brought low. Let me pause here and ask you something directly. Have you ever experienced this kind of treatment? Have you ever been singled out, searched, questioned, made to feel like a suspect when you had done absolutely nothing wrong? Type yes in the comments if this resonates with your own experience. These stories need to be shared, and your experiences matter. Officer Hartwell found nothing in her luggage because there was nothing to find. Her bag contained exactly what you would expect from a professional woman taking a short business trip: appropriate clothing, basic toiletries, a book for the flight, and her conference materials. He repacked nothing. He left her belongings spread across the bench like evidence at a crime scene. Then he demanded to search her handbag. Judge Whitmore handed it to him without protest, though her jaw was now tight with the effort of containing her response. He upended the bag, dumping its contents onto the bench beside her displaced clothing. Her wallet tumbled out along with her keys, phone charger, reading glasses, breath mints, a small package of tissues, and a leather-bound notebook that she used for case notes and personal reflections. He picked up the notebook and began flipping through its pages. This was different. This crossed a line that even his previous behavior had not crossed. The notebook contained her professional observations, her preliminary thoughts on cases, notes from meetings with attorneys and colleagues. It contained information that was privileged, confidential, protected by principles that form the foundation of the legal system she served. She spoke firmly, but without raising her voice. She told him that the notebook contained privileged legal material and that he had no authority to examine its contents. He ignored her completely. He continued turning pages, his eyes scanning her handwriting, invading the most private corners of her professional mind. She watched him reading her words and felt something shift inside her. The cold, controlled anger that had been building throughout this encounter transformed into something harder, more purposeful. This man had made a serious mistake. He did not yet understand how serious. She reached into the pile of belongings on the bench and retrieved her phone. She opened the camera application and began recording video. The effect on Officer Hartwell was immediate and dramatic. His head snapped up from the notebook. His expression, which had been one of casual dominance, shifted to something closer to alarm. He ordered her to stop recording and put the phone away. She kept the camera steady and replied in the same measured tone she used when issuing rulings from the bench. She stated that she was within her legal rights to record a public official performing their duties in a public space. She noted that she intended to continue recording until this encounter concluded. He stepped toward her, closing the distance between them in a way that was clearly meant to intimidate. His physical presence loomed over her, his body language aggressive and threatening. He repeated his order to stop recording, louder this time, with an edge of menace in his voice. She did not lower the phone. She did not step back. She simply looked at him with the steady gaze of someone who had faced down actual criminals, people who had committed violent acts, people who had nothing left to lose and had never once flinched. Whatever threat Officer Hartwell thought he projected, it did not compare to what she had already encountered and overcome in her career. The standoff might have continued indefinitely, but at this moment, another figure entered the frame of Judge Whitmore's recording. Officer Patricia Medina had been working a different section of the terminal when she noticed the commotion near Gate 22. She approached her fellow officer and asked, in a tone that suggested genuine uncertainty, what was happening here. Officer Hartwell, without taking his eyes off Judge Whitmore and her phone, stated that he was conducting a standard security check. Officer Medina looked at the bench covered with disheveled clothing and personal items. She looked at Judge Whitmore, who stood with quiet dignity amid the wreckage of her privacy. She looked at the phone recording everything. Her expression suggested that she understood, perhaps better than her colleague, how this situation appeared. She asked Officer Hartwell what had prompted this particular security check. He said it was random selection. Even in the stress of the moment, his answer carried a hollowness that would later prove devastating in testimony. Officer Medina's eyes moved across the stream of passengers continuing past them, not one of whom had been subjected to any similar attention. Judge Whitmore addressed Officer Medina directly. She stated clearly that she believed she was being racially profiled. She noted that she had fully cooperated with every request, had presented identification and boarding documentation, had allowed both her bags to be searched, and that nothing suspicious had been discovered. She said that she wanted Officer Hartwell's badge number and the name of his supervising officer. She said all of this calmly, precisely, in the voice that generations of law students would have recognized from courtroom recordings studied in civil procedure classes. Officer Hartwell's response was to accuse her of being disruptive and causing a scene. The accusation was absurd on its face. Judge Whitmore had not raised her voice. She had not moved from her position. She had not made any gesture that could be interpreted as threatening. She had simply stood still, spoken clearly, and documented what was being done to her. But Officer Hartwell needed justification for his behavior, needed to reframe this encounter as something other than what it so obviously was. He told her that if she did not calm down, he would have her removed from the airport. The threat was so disconnected from reality that Judge Whitmore might have laughed in other circumstances. She was perfectly calm. Anyone watching the recording would later confirm that her demeanor throughout this encounter was nothing short of remarkable in its composure. She asked again for his badge number. He reached for her arm. The moment his hand made contact with her wrist, several things happened in rapid succession. Judge Whitmore stated clearly that she did not consent to being touched, that she was not under arrest, and that she wanted to know on what legal grounds she was being detained. Her voice remained steady, but there was steel in it now, the unmistakable authority of someone who knew exactly where the boundaries of lawful conduct lay and recognized when those boundaries had been violated. Officer Hartwell stated that she was being detained for suspicious behavior. Judge Whitmore asked him to specify what behavior was suspicious. He could not answer. He mumbled something about her demeanor, about inconsistencies in her responses, but he could point to nothing concrete, because there was nothing concrete to point to. Her behavior had been cooperative to the point of exemplary. Her responses had been entirely consistent. The only thing that had distinguished her from every other passenger in that terminal was her race, and he could not say that out loud. Officer Medina intervened quietly, suggesting that perhaps they should call a supervisor to sort this out. The look that Officer Hartwell gave his colleague was captured clearly on Judge Whitmore's recording. It was a look of betrayal, of anger at being undermined, of a man who had invested too much in this confrontation to back down gracefully. He told Judge Whitmore that she needed to accompany him to the security office for additional screening. She asked if she was being arrested. He said no. She asked if she was free to leave. He said no. She observed, with devastating precision, that these two answers were logically incompatible. Either she was being detained lawfully, in which case there must be probable cause, and she was entitled to know the grounds, or she was free to go. He could not have it both ways. A small crowd had formed around them now. Air travel creates a strange kind of enforced community among strangers, and that community had recognized that something wrong was happening in their midst. People had stopped to watch. Several had their own phones out, recording from different angles. This multiplicity of footage would later prove crucial, providing corroboration that no defense attorney could challenge and no police union could explain away. Officer Hartwell noticed the gathered witnesses, and his discomfort became visible. He raised his voice and ordered everyone to continue on their way. Most of them did not move. There is something powerful about collective witness, about the presence of observers who refuse to look away from injustice. Those strangers, whose names Judge Whitmore did not yet know, were providing a form of protection simply by staying and watching. The standoff continued for several more minutes before a supervisor finally arrived. Sergeant Michael Torres was a man in his late 50s with a weary expression that suggested he had seen too many situations like this one and had long ago grown tired of cleaning up after officers who should have known better. He assessed the scene quickly, taking in the scattered belongings, the recording phones, the defensive posture of his officer, and the composed dignity of the woman he had targeted. Sergeant Torres apologized to Judge Whitmore. He offered to help her repack her belongings. He offered to personally escort her to her gate. Judge Whitmore declined these offers. Her flight had already departed. She had missed her boarding call while being detained for crimes she had not committed and suspicions that existed only in the prejudiced mind of Officer Dennis Hartwell. No amount of belated courtesy could undo what had been done to her. Instead of accepting apologies, Judge Whitmore began collecting information. She requested Officer Hartwell's full name and badge number. She requested Officer Medina's full name and badge number. She requested Sergeant Torres's information, along with the contact information for the Airport Police Department's Internal Affairs Division, the Civilian Oversight Board, and the Airport Authority's administrative offices. She requested the names and contact information of any witnesses willing to provide them. Sergeant Torres's demeanor shifted as this list of requests extended. He became less apologetic and more wary. He began offering explanations, suggesting that Officer Hartwell had simply been doing his job, that airport security required difficult judgment calls, that she should not take any of this personally. Judge Whitmore listened to these deflections without expression. When he finished, she smiled, and those who witnessed that smile would later describe it as one of the most unsettling things they had ever seen. It was not a warm smile. It was the smile of someone who has just been handed exactly what they needed. She told Sergeant Torres that she looked forward to explaining in federal court precisely what she thought of how Officer Hartwell did his job. She said she anticipated that the court would be very interested in the judgment calls that had been made this morning. She said that she hoped the airport authority had adequate insurance because they were going to need it. She did not reveal that she was a judge. This was strategic. She wanted to see how the department would respond to a complaint from someone they perceived as an ordinary citizen without connections or power. She wanted to test whether their systems actually worked, whether complaints were investigated seriously, whether accountability was possible within their institutional framework. She had a professional interest in understanding how these systems function from the inside, and she had a personal interest in documenting their failures. What do you think happened when she filed her complaint? Do you think the department took it seriously, or do you think they did exactly what institutional power usually does when confronted with evidence of its own misconduct? Judge Whitmore rebooked on a flight departing 4 hours later. She found a quiet corner of the terminal, purchased a cup of tea she did not drink, and spent the next 3 hours documenting everything that had happened. She wrote a detailed narrative of the encounter, working from memory and from the timestamps on her video recording. She captured every question Officer Hartwell had asked her, every response she had given, every reaction she had observed from the officers and from the surrounding witnesses. She was meticulous. Decades of legal work had trained her to understand that details matter, that cases are won or lost on specificity, that vague allegations are easy to dismiss, while precise documentation is difficult to ignore. She noted the exact time the encounter began, according to her phone. She noted the duration of each phase. She noted the names of the witnesses who had provided their contact information, 17 people who had stayed behind after the crowd dispersed to offer their support and their willingness to testify about what they had seen. She uploaded her video recording to 3 different cloud storage services. She emailed copies to herself at multiple addresses. She texted the video file to her adult daughter with instructions to save it and share it with their family attorney if anything happened to her. She understood how evidence could disappear, how files could be corrupted, how phones could be lost or confiscated. She was not going to let that happen to the documentation of her own mistreatment. When she finally boarded her rescheduled flight, she was exhausted in a way that had nothing to do with physical tiredness. The adrenaline that had sustained her through the encounter and its immediate aftermath had faded, leaving behind a bone-deep weariness and a simmering rage that she would carry with her for months. She closed her eyes during takeoff and thought about all the people who had experienced what she had experienced, but who did not have her resources, her knowledge, her professional standing. She thought about how many travelers had been humiliated by Officer Hartwell, and officers like him had filed complaints that went nowhere, had been ground down by a system designed to protect its own. She thought about what she was going to do about it. She arrived at the conference 6 hours late. She had missed the opening reception and the networking dinner. She had missed the opportunity to connect with colleagues she saw only at annual gatherings, but she had not missed her keynote slot, which was scheduled for the following morning. She spent that evening in her hotel room rewriting her speech entirely. The next morning, she stood before an audience of 300 judges, prosecutors, defense attorneys, and legal scholars. She was supposed to talk about theoretical frameworks for understanding bias in the justice system. Instead, she told them what had happened to her at the airport less than 24 hours earlier. She described the encounter in precise detail. She played portions of her video recording on the conference room's projection screen. She let them see the undergarments laid out on the bench, the notebook being rifled through, the finger pointed in her face, the arm grabbed without consent or justification. The audience was stunned. These were people who dealt with injustice professionally, who read about civil rights violations in case files and appellate decisions. But there was something different about watching it happen to someone they knew, someone they respected, someone who sat on the same bench they did. Several people were visibly crying. Others sat in rigid silence, their faces masks of controlled fury. When she finished, the room erupted in a standing ovation that lasted nearly 3 minutes. Attorneys approached her afterward in waves, offering their services, their connections, their expertise. Civil rights litigators pressed business cards into her hands. Legal scholars asked if they could cite her experience in their research. Journalists who covered legal affairs requested interviews. Judge Whitmore thanked everyone graciously and explained that she had not yet decided on her course of action, but inside she had already decided. She was going to pursue this as far as the law would allow. She was going to make an example of Officer Dennis Hartwell and the institution that had enabled him. Back home the following week, she began the formal process of seeking accountability. She filed a written complaint with the Airport Police Department's Internal Affairs Division. The complaint was 12 pages long and included her video recording, her written narrative, and the contact information for all 17 witnesses who had agreed to be interviewed. She sent copies of this complaint to the city's Civilian Police Oversight Board, the State Aviation Authority, the Federal Aviation Administration, and the Department of Transportation's Office of Civil Rights. She also sent copies to 3 news organizations that she knew would be interested in the story and to the most prominent civil rights law firm in the region, accompanied by a letter expressing her interest in discussing potential legal action. She was building pressure from multiple directions simultaneously, creating a situation where the department could not simply bury her complaint in bureaucratic process. The response from the Airport Police Department arrived 26 days later. It was a form letter clearly generated from a template, thanking her for bringing her concerns to their attention. The letter stated that her complaint had been reviewed and that appropriate action had been taken. It did not specify what action. It did not acknowledge any wrongdoing. It did not provide any information about what, if anything, would change as a result of her experience. The letter was signed by an administrative coordinator in the Human Resources Department, not by the Chief of Police, not by anyone in Internal Affairs, not by anyone with apparent authority over disciplinary matters. It was the kind of response designed to make complaints go away, to satisfy procedural requirements while doing absolutely nothing of substance. Judge Whitmore had expected exactly this. She had seen similar responses in cases that came before her court, had watched defendants argue that their complaint procedures were adequate while producing evidence that those procedures were facades. Now she had her own evidence of how the facade operated. This was when she revealed who she was. She held a press conference on the steps of the federal courthouse in her city. She wore her judicial robe, the black garment that symbolized the authority of the law and the impartial administration of justice. Beside her stood attorney Camille Okonjo, a legendary civil rights litigator who had won verdicts and settlements totaling over $40 million from law enforcement agencies across the country. Okonjo was known for her meticulous preparation, her devastating cross-examinations, and her absolute refusal to accept anything less than full accountability. Judge Whitmore read a prepared statement describing what had happened to her at the airport. She detailed Officer Hartwell's behavior, the department's dismissive response to her complaint, and her decision to pursue federal legal action. She announced that she was filing suit in federal district court against Officer Dennis Hartwell, Officer Patricia Medina, Sergeant Michael Torres, and the Airport Police Department itself. The suit alleged violations of her Fourth Amendment rights against unreasonable search and seizure, her 14th Amendment rights to equal protection under the law, and various state civil rights statutes. She played portions of her video for the assembled journalists. She displayed photographs of her belongings spread across the terminal bench. She read excerpts from the department's form letter response, and then she took questions. The first question was whether she thought being a judge made her experience different from that of ordinary citizens. She answered that it absolutely should not have, that the Constitution's protections applied to everyone regardless of their profession, and that was precisely the point. She said that if a sitting judge could be treated this way, imagine what happened to people without her resources, her knowledge, or her platform. She said that she was pursuing this case not primarily for herself, but for the countless travelers who had been similarly mistreated and who had no path to accountability. The second question was whether she had any evidence that Officer Hartwell had engaged in similar behavior before. She said that she expected discovery in the lawsuit would reveal a great deal about Officer Hartwell's history and about the department's pattern of handling complaints. She said she would let the evidence speak for itself. The third question was about the damages she was seeking. Attorney Okonjo stepped to the microphone to answer this one. She said they were seeking both compensatory damages for Judge Whitmore's emotional distress, humiliation, and the professional consequences of missing her speaking engagement, and punitive damages sufficient to send a message that this kind of behavior would not be tolerated. She said the specific amount would be determined at trial, but she expected it to be substantial. The story detonated across the media landscape. Local news led with it that evening. Regional outlets picked it up within hours. By the following morning, it had reached national coverage. The footage was irresistible. A distinguished judge in her robes standing beside her attorney, playing video of herself being treated like a criminal suspect by a uniformed officer who had no idea who he was dealing with. Social media erupted. The video clips were shared hundreds of thousands of times within the first day. Hashtags emerged and began trending. Civil rights organizations issued statements of support. Political figures, carefully gauging the wind, released their own condemnations of what the footage showed. The airport authority issued a statement saying they took the allegations seriously and were conducting a thorough review of the incident. They placed Officer Hartwell on administrative leave with pay. The placement on paid leave only intensified public anger. Here was an officer captured on video engaging in what appeared to be clear racial profiling, and his punishment was a paid vacation while his victim had been forced to hire attorneys and relive her trauma in public. The optics were terrible, and the airport authority seemed incapable of understanding why. Within the first week after the press conference, Attorney Okonjo's office was contacted by 31 other people who claimed to have had similar experiences with Officer Hartwell. Within a month, that number had grown to 58. The legal team began the painstaking process of interviewing each one, documenting their experiences, and identifying those whose accounts could be corroborated and whose cases fell within the statute of limitations. The pattern that emerged was damning. Officer Hartwell had been targeting black and brown travelers for years. His victims included a retired military colonel who had served 3 combat tours and was returning from his granddaughter's christening. They included a physician who had been racing to catch a flight to perform emergency surgery on a child and who had missed that flight due to Hartwell's intervention, though thankfully a colleague had been able to step in. They included a graduate student who had been subjected to such invasive questioning about her research that she had suffered panic attacks for months afterward. One woman described how Hartwell's detention had caused her to miss the last flight that would have allowed her to reach her mother's bedside before she died. Another told of being detained so long that she missed a crucial job interview, one that she had spent 6 months preparing for and that represented her best chance to escape an abusive employment situation. A young man described Hartwell examining his clothing and asking, with obvious skepticism, whether items were authentic or knockoffs, implying that a young black man could not legitimately possess nice things. Each story was different in its specifics, but identical in its essence. Hartwell selected his targets based on their race. He subjected them to searches and questioning that had no legitimate security purpose. He seemed particularly drawn to black travelers who appeared successful or professional, as if their evident accomplishment was itself an affront that needed to be addressed. And when his victims complained, the department closed ranks and protected him. The legal team subpoenaed Officer Hartwell's personnel file, What they found confirmed everything the victims had described. Hartwell had accumulated 8 formal complaints for racial profiling over his 12-year career with the airport police department. 8 complaints from 8 different people, all describing essentially the same behavior. Every single complaint had been dismissed or resolved with minimal discipline. A written warning here, a note in his file there, a mandatory training session that he had apparently slept through, based on the testimony of the officer who had administered it. The department's own internal statistics, obtained through discovery, showed that Hartwell had conducted stop and search procedures on black passengers at a rate nearly 20 times higher than his rate for white passengers. 20 times. And his success rate, the percentage of searches that actually discovered contraband or security violations, was actually lower for black passengers than for white ones. His targeting was not just racist, it was counterproductive from a pure security standpoint. He was wasting resources on innocent people while potentially missing actual threats. The lawsuit moved through the federal court system. The airport authority filed motions to dismiss, arguing that Hartwell had been acting within his discretionary authority and that the department had adequate policies against racial profiling. The judge assigned to the case, not Judge Whitmore, obviously, but a federal district judge with a reputation for careful analysis, denied the motion. She wrote that the allegations, if proven, would constitute clear violations of constitutional rights and that the plaintiff was entitled to her day in court. Discovery proceeded, depositions were taken. Officer Hartwell's testimony was, by all accounts, a disaster for the defense. He was defensive, evasive, and prone to anger when confronted with evidence of his own behavior. When asked to explain why he had selected Judge Whitmore for screening, he said she had appeared nervous. When shown the video which depicted a woman of remarkable composure, he said that nervousness could be internal. When asked what specific behaviors had indicated internal nervousness, he could not identify any. His attorney attempted to frame his actions as reasonable exercise of professional judgment in a high-security environment. Attorney Okonjo methodically demolished this framing. She walked through each element of the encounter, asking Hartwell to identify the specific security concern that justified each action. Why did he need to know where she worked? He couldn't say. Why did he need to lay her clothing out on a public bench rather than examining it in her bag? He couldn't say. Why did he need to read through her notebook? He couldn't say. The cumulative effect was devastating. Officer Medina's deposition was more nuanced and, in some ways, more damaging to the department's defense. She admitted that she had felt uncomfortable during the encounter. She admitted that she had questioned Hartwell's selection of Judge Whitmore. She admitted that she had suggested calling a supervisor and that Hartwell had refused. She admitted that she should have done more to intervene, should have insisted on supervisor involvement, should have documented her concerns through official channels. Her testimony painted a picture of a department where officers knew that certain colleagues engaged in problematic behavior, but felt powerless or unwilling to report it. She described a culture where raising concerns about fellow officers was seen as disloyalty, where complaints were viewed skeptically, where the path of least resistance was to look the other way and hope that nothing too serious happened on your watch. The trial took place 13 months after the airport encounter. It lasted 11 days. The courtroom was filled to capacity every day with journalists, civil rights advocates, and members of the public who had followed the case. Outside the courthouse, demonstrators gathered with signs calling for justice and police accountability. Judge Whitmore testified for nearly 6 hours, over 2 days. She walked the jury through the encounter in meticulous detail, using her video recording and her contemporaneous notes to anchor her account in indisputable specificity. She described not just what had happened, but how it had made her feel. The humiliation of having her undergarments displayed publicly, the violation of having her private thoughts examined by a stranger, the fear when Hartwell grabbed her arm, not knowing how far he was willing to escalate. She talked about the aftermath, the sleepless nights, the hypervigilance she now experienced in airports, the way she tensed whenever she saw a uniformed officer approaching. She talked about the professional impact, the speech she had been unable to deliver as planned, the colleagues who had witnessed her humiliation via video. She talked about the deeper wound, the reminder that despite her achievements, despite her position, despite everything she had earned through decades of hard work, she could still be reduced to a suspect in seconds based on nothing more than her skin color. The witnesses who had observed the encounter testified one by one. They described what they had seen, and their accounts were remarkably consistent. A businessman who had been rushing to catch his own flight described stopping because something felt wrong about what he was witnessing. A mother traveling with 2 children described positioning herself to record because she wanted evidence in case things escalated. A retired teacher described the look on Judge Whitmore's face as her belongings were spread across the bench, and she started crying on the stand as she recalled it. The other victims of Hartwell's profiling testified as well. Not all 58, that would have taken weeks, but a carefully selected group whose experiences spanned his career and illustrated the pattern. The retired colonel testified in his military dress uniform, his chest covered with ribbons representing decades of service to the country, and described being treated like a threat by a man who had never served anything but his own prejudices. The physician described the child whose surgery had almost been delayed. The graduate student described the panic attacks that had followed her encounter. Expert witnesses provided context and analysis. A sociologist who studied implicit bias in policing explained how Hartwell's behavior fit a well-documented pattern of racial profiling. She described the psychological mechanisms that led some officers to perceive black individuals as more threatening or suspicious, regardless of their actual behavior. She explained how these biases were reinforced by departmental cultures that failed to challenge them. A statistician presented analysis of Hartwell's stop and search records compared to department-wide averages and to objective indicators of actual security threats. The numbers were stark. Hartwell had targeted black passengers at 21 times the rate of white passengers. His searches of black passengers had yielded contraband at a rate of 0.3%. His searches of white passengers had yielded contraband at a rate of 0.7%. His profiling was not just morally wrong, it was empirically ineffective. The defense presented its own case, though it seemed half-hearted by comparison. Character witnesses described Hartwell as a dedicated officer and a good family man. His attorney argued that he had been following his training and his instincts, that airport security required difficult judgment calls, that not every mistake was evidence of racism. The arguments felt thin against the weight of evidence that had been presented. In closing arguments, Attorney Okonjo stood before the jury and asked them to consider what message their verdict would send. She said that Officer Hartwell had believed he could treat a black woman as a criminal suspect without consequence, just as he had treated so many others before her. She said that the department had believed it could protect him from accountability, just as it had protected him for over a decade. She said that the jury had the power to prove them both wrong. The defense argued that damages, if any were awarded, should be modest. They argued that Judge Whitmore had not suffered physical injury, had not lost her job, had not experienced financial hardship. They argued that punitive damages were unwarranted because the department had policies against racial profiling, even if those policies had not been effectively enforced. The jury deliberated for 8 hours. When they returned, the 4 women announced their verdict. They found in favor of Judge Whitmore on every count. They found that Officer Hartwell had violated her constitutional rights through racial profiling and unlawful detention. They found that Officer Medina had failed in her duty to intervene to prevent the violation. They found that Sergeant Torres had been negligent in his supervision and his response. And they found that the Airport Police Department had maintained a pattern and practice of tolerating racial profiling in violation of federal civil rights law. The damages award exceeded what most observers had expected. The jury awarded Judge Whitmore $250,000 in compensatory damages for her emotional distress, humiliation, and reputational harm. Then they awarded $4.3 million in punitive damages designed to punish the defendants and to deter future misconduct. The total verdict was $4.55 million. The amount was not really about the money. Judge Whitmore would later say that she would have pursued the case, even if the only possible outcome had been a judgment of $1. It was about the principle, about the message, about creating consequences that would make the next officer think twice before targeting the next black traveler. The size of the punitive damages reflected the jury's assessment of how egregious the department's conduct had been and how strong a message was needed to change it. The airport authority announced that it would appeal. Their attorneys filed briefs arguing that the punitive damages were excessive, that they bore no reasonable relationship to the compensatory harm, that they violated due process. The case made its way to the federal appellate court, where a 3-judge panel heard arguments and reviewed the record. 16 months after the trial verdict, the appellate court issued its decision. The panel upheld the verdict in full. In a 43-page opinion, they wrote that the department's decade-long pattern of tolerating Officer Hartwell's misconduct, combined with their dismissive response to Judge Whitmore's complaint, demonstrated precisely the kind of deliberate indifference to constitutional rights that punitive damages were designed to address. They noted that 8 previous complaints had produced no meaningful change in Hartwell's behavior, suggesting that anything less than a substantial financial penalty would be insufficient to motivate reform. The legal consequences were devastating, but they were only the beginning. The human consequences spread outward in waves, touching everyone connected to the events of that Thursday morning. Officer Dennis Hartwell was terminated from the Airport Police Department 4 days after the trial verdict, before the appeal was even filed. His peace officer's certification was revoked by the state licensing board, meaning he could never work in law enforcement anywhere in the state again. At 49 years old, after 23 years in police work, he found himself unemployable in the only profession he had ever known. He tried to find other work. Security companies would not hire him because his name was too well known, his face too associated with the viral video that had been viewed millions of times. Private investigation firms worried about the liability of employing someone with his record. Even jobs that had nothing to do with security or law enforcement proved elusive because every background check, every internet search, every reference request led back to the same story. His personal life collapsed under the weight of public disgrace. His children faced relentless bullying at school, their classmates having seen the videos and the news coverage. His marriage, already strained by the stress of the lawsuit and the trial, did not survive. His wife filed for divorce 18 months after the verdict, citing irreconcilable differences, though the real difference was that she could no longer live with the man the trial had revealed him to be. These were not outcomes that Judge Whitmore had wished for. She had not pursued the lawsuit to destroy a man's family or to leave his children fatherless in any practical sense, but they were the natural consequences of his own choices, the inevitable results of years of behavior that he had believed would never catch up with him. Every black traveler he had humiliated, every complaint that had been ignored, every day he had continued treating people as suspects because of their skin color, had been a choice. The consequences of those choices were his to bear. Officer Patricia Medina received a 6-month suspension without pay and a permanent demotion. She returned to duty in a reduced capacity, her career effectively over in any meaningful sense. Within 2 years, she resigned from the department and took a job with a private security company, earning significantly less money and carrying the permanent knowledge that she had witnessed injustice and failed to stop it when she had the chance. Sergeant Michael Torres retired 7 months after the verdict, earlier than he had planned, and without the ceremonial recognition usually afforded to officers with his length of service. His pension remained intact, a financial security that some felt he did not deserve given his role in enabling Hartwell's behavior. But his professional legacy was forever tainted, his name permanently associated with the failure to address obvious misconduct within his command. The Airport Police Department itself underwent a transformation that would take years to complete. The Department of Justice opened a civil rights investigation based on the evidence that had emerged during the trial. That investigation resulted in a consent decree, a legally binding agreement that placed the department under federal oversight for a minimum of 5 years. Under the terms of the consent decree, the department was required to implement comprehensive new training on racial bias and constitutional limitations on searches. They were required to install an independent civilian oversight board with real authority to investigate complaints and recommend discipline. They were required to maintain detailed records of all stop and search encounters, including the race of the subject and the outcome of the encounter, and to submit those records to regular statistical analysis. They were required to hire an independent monitor who would report to the court on their progress. The internal house cleaning was extensive. The investigation that followed the trial identified 23 officers whose records showed patterns similar to Hartwell's, though none as extreme. 9 of those officers were terminated, 6 were suspended and demoted. The remainder received formal discipline and mandatory retraining with the understanding that any future incidents would result in immediate dismissal. The department's leadership was gutted. The chief of police retired under pressure before he could be forced out. 2 assistant chiefs were demoted and transferred to administrative positions with no supervisory authority. The entire Internal Affairs Division was reconstituted with new personnel and new procedures designed to ensure that complaints were actually investigated rather than simply processed and filed away. Judge Whitmore used her portion of the settlement to establish something that would outlast the immediate case. She created the Equal Skies Legal Fund, a nonprofit organization dedicated to providing free legal representation to victims of racial profiling in airports and other transportation settings. The fund was staffed by attorneys who believed in the cause and supported by donations from civil rights organizations and individuals who had followed her case. In its first 2 years of operation, the Equal Skies Legal Fund took on 47 cases. 19 resulted in settlements, totaling over $3 million in compensation for victims who would otherwise have had no recourse. 6 went to trial, and 5 of those resulted in verdicts for the plaintiffs. The fund also engaged in policy advocacy, pushing for legislative reforms at the state and federal level, working with airlines and airport authorities to improve their training and oversight procedures. Judge Whitmore testified before her state legislature about the need for stronger legal protections against racial profiling in transportation settings. She spoke to congressional committees about federal legislation that would establish clearer standards and create dedicated funding for oversight. She gave interviews, wrote articles, and spoke at conferences, using her platform to keep attention focused on an issue that affected millions of travelers every year. Not all of her advocacy resulted in immediate change. Legislative processes move slowly, and entrenched interests resist reform. But some laws were strengthened, some policies were updated, some training programs were improved. The needle moved, perhaps not as far or as fast as she would have liked, but it moved. 4 years after the airport encounter, Judge Whitmore announced her candidacy for a seat on her state's Supreme Court. The campaign was grueling, as all statewide campaigns are, but she had assets that most candidates lacked. Her story was known, her courage was documented, her commitment to justice had been tested in the most personal way possible and had not been found wanting. She campaigned on a platform of fairness and accountability, arguing that the courts needed justices who understood injustice from experience as well as from legal theory. She talked about her airport encounter not to seek sympathy, but to illustrate why perspective matters, why the bench needs people who have seen the system from the other side. She won the election by a margin of 11 points, a landslide by the standards of judicial elections. On the day she was sworn in as Justice Whitmore, she thought about Officer Dennis Hartwell, who had looked at her and seen a suspect, a target, a person without power. She wondered if he was watching, if he understood yet what he had done when he decided to make her a victim. She doubted it. Some people never learn, no matter how steep the price of their education. Let me ask you something directly. What would you have done in her situation? Would you have fought like she did, knowing how difficult and exhausting and public the battle would be? Or would you have tried to put it behind you and move on with your life? There is no wrong answer. Not everyone can fight every battle. But her choice to fight changed things for people she will never meet, and that is worth thinking about. Hartwell, meanwhile, continued his descent. The last reliable reports placed him working a series of temporary jobs, never staying anywhere long, never rebuilding anything like the life he had once had. His name remained searchable, his face recognizable, his story permanently archived in the digital memory of the internet. Every potential employer who searched for him found the same videos, the same articles, the same court documents. His past followed him like a shadow that no amount of time would disperse. Some people expressed sympathy for his situation, arguing that he had already lost everything and deserved a chance at redemption. Others felt that his consequences were proportionate to the harm he had caused, not just to Judge Whitmore, but to dozens of other victims over more than a decade. Justice Whitmore herself, when asked about Hartwell in interviews, declined to express satisfaction at his suffering. She said that her goal had never been to destroy him personally, but to create accountability that would prevent similar harm to others. Whether he found redemption was between him and his conscience. Her concern was the people he might have victimized if he had been allowed to continue. The airport where everything happened is different now. Officers who work there undergo extensive training on bias and constitutional rights. Complaints are investigated by an independent board rather than by colleagues protecting their own. Statistical analysis ensures that any officer who shows patterns of discriminatory targeting is identified and addressed before the problem grows to the scale it reached with Hartwell. A plaque was installed in Terminal C, near the spot where Judge Whitmore was detained. It does not name her or tell her story directly. It simply states the airport's commitment to treating all travelers with dignity and respect, regardless of race, religion, national origin, or any other characteristic. Some people think the plaque is performative, a public relations gesture rather than a meaningful change. Perhaps it is, but thousands of travelers walk past it every day, and some of them read it, and some of them think about what it means, and that is something. Justice Whitmore still travels regularly for her work on the Supreme Court. She still goes through airports, still passes through security checkpoints, still encounters uniformed officers whose job includes deciding who looks suspicious. Most of them recognize her now. Most of them look away quickly, perhaps embarrassed by association with what one of their profession did to her, perhaps simply uncomfortable in the presence of someone who has demonstrated what accountability can look like. A few have approached her over the years to apologize on behalf of their profession, to assure her that they would never behave as Hartwell did, to express their commitment to equal treatment. She accepts these overtures graciously, though she knows that individual good intentions do not solve systemic problems. The system that enabled Hartwell exists in airports across the country, in police departments of every size, in institutions wherever power is exercised with insufficient oversight. Sometimes, when she is walking through an airport terminal, she sees a young black traveler being pulled aside for additional screening. When circumstances permit, she stops. She watches. She lets the officers know that someone is paying attention. And if things seem wrong, if the encounter carries the flavor of harassment rather than legitimate security, she is not afraid to intervene, to ask questions, to pull out her phone. She knows from personal experience how much difference it can make when someone refuses to just walk by. Those strangers who stopped to watch her encounter with Hartwell, who recorded on their phones, who gave her their contact information, who testified at trial, they were part of what made justice possible. She tries to be that person for others when she can. Officer Dennis Hartwell made a choice on that Thursday morning at 7:23 a.m. He saw a successful black woman walking through an airport terminal with quiet confidence, and he decided that she needed to be reminded of her place, that her evident accomplishment was somehow suspicious, that his authority entitled him to humiliate her for the crime of being black and prosperous at the same time. He was wrong about everything, wrong about his authority, wrong about his immunity from consequence, wrong about the woman he targeted and what she was capable of. That wrongness cost him his career, his marriage, his reputation, his place in the world. It exposed a pattern of misconduct that had been allowed to fester for over a decade. It led to reforms that made the system at least somewhat better for the travelers who came after. Justice is not always swift. Justice Whitmore knows this better than most. She has spent her career watching the slow grind of legal processes, the delays and continuances and appeals that can stretch cases for years. She has seen guilty people escape consequence and innocent people punished. She has no illusions about the system she serves, its limitations, its biases, its many failures. But she also knows that justice does sometimes arrive, that when brave people are willing to fight for it, when evidence is documented and preserved, when witnesses come forward and institutions are forced to account for their failures, change is possible. Not inevitable, not easy, but possible. That is what happened here. One woman refused to accept being treated as less than human. She documented what was done to her. She pursued every available channel of accountability. She used her skills, her knowledge, her resources, and her platform to demand better, not just for herself, but for everyone who would come after. And because she did, things changed. Not everywhere, not perfectly, But somewhere, right now, a black traveler is walking through an airport where they will not be stopped based on their race because the officer who might have stopped them has been trained differently or supervised more closely or deterred by the knowledge that consequences exist for misconduct. That traveler will never know what they were spared. They will simply catch their flight, attend their meeting, visit their family, live their life. And that invisible protection is the real legacy of what happened that Thursday morning in Terminal C. Thank you for staying with this story until the end. If it made you think differently about anything, if it showed you something about justice or courage or the possibility of change, I would love to hear your thoughts in the comments. And if you want more stories like this one, stories that go deep into the moments that shape lives and reveal truths about our society, subscribe to this channel. Your support makes this work possible, and there are many more stories waiting to be told.